The law requires employers and unions to bargain in good faith. But does good faith require that a party provide information to verify its bargaining position? In NLRB versus Truitt Manufacturing, the United States Supreme Court examined this question in the context of an employer's asserted inability to pay higher wages. Truitt Manufacturing was negotiating with a union which demanded a 10-cent per hour pay raise for some of Truitt's employees. Truitt replied that it couldn't afford a 10-cent increase because the company was undercapitalized, it had never paid dividends to shareholders, and any raise greater than 2.5 cents would put it out of business. The union asked Truitt for financial data to support the company's claimed inability to pay. The union stated that such information was necessary to help employees decide whether to continue negotiating for a raise. Truitt refused to provide the information. The National Labor Relations Board found that Truitt violated the National Labor Relations Act by failing to bargain in good faith. The board ordered Truitt to provide information to the union substantiating its alleged inability to pay. A federal appellate court refused to enforce the board's order, and the Supreme Court granted cert.